Okay, thank you very much for joining us today. Today's masterclass is titled "What Should Block Managers Do in Respect of EWS1 Forms?" We're joined by a highly prestigious and insightful group of panelists today, some real industry leaders, and we'll come on to them in a moment. Some general housekeeping for those of you who haven't seen any of our webinars before. You are in mute or listen-only mode by default, which helps to reduce the background noise for all of the other attendees at the webinar. But we would ask and encourage you to submit your questions. So we know that there are lots of people who will be listening today who have lots of questions. Please do submit them as we go. We'll try and pick them up as we go, and we have a dedicated section towards the end of this webinar in which we're going to pick up some of the key themes that you're asking and putting them to our panelists. So if you want to submit a question, please use the go to webinar box, which by default will appear on the right hand side of your screen. Type it in and it will go through to the Fixflo moderator. So without further ado, and given how much we have to get through, the final part of housekeeping is that today's presentation is for general information purposes only. It shouldn't be taken as or construed as anything other than general information, so it is specifically not legal guidance. And with that in mind, I'd like to introduce you to our panelists. So if we could take them in the order in which they appear on screen. John, could you please introduce yourself to the audience?
Okay, yeah, thanks, Rajiv. John Bagley from the Royal Institution of Chartered Surveyors, Tangible Assets Valuation Director. That essentially is valuation standards, residential and commercial property, UK and Europe, and I've been heavily involved in the cladding piece and EWS over the last 18 months or so.
Excellent, thank you. Andrew?
So, Andrew Bulmer, Chief Exec of the Institute of Residential Property Management.
Thank you. Nigel?
Nigel Glenn, CEO of ARMA.
And Cass?
Last but not least, being last in the alphabet, I'm Cassandra Zanelli, solicitor and partner at PM Legal Services.
Excellent, thank you, and thank you very much for agreeing to share your insights and thoughts with the audience today, all of you. It's hugely appreciated. In terms of structure, so in an effort to bring everybody to the sort of same starting point, we're going to start with a general introduction to the EWS1 regime. So what brought it about, why do they exist, the buildings that they apply to, and the sort of signatory requirements, so who is able to sign. And from there, we're going to dive into some of the questions. So a lot of these questions have been fueled by comment, insight, and questions received during our webinar series to date. So this is definitely a hot topic for the sector, and we're going to do our best to provide as much clarity as possible, albeit in perhaps circumstances where clarity may not always be available. So without further ado, I'd like to hand over to John. John, would you mind talking us through what brought about the need for the EWS1 forms, the problems they're looking to address, and the general background to this topic?
Yeah, okay, thanks. Yeah, probably appropriate to almost rewind 3 years or so to the period post Grenfell, and that sort of gives quite a good story for why we are where we are now, and having the conversations we are having about a process about checking buildings essentially retrospectively. In the aftermath of Grenfell, it was well documented in terms of challenges and known problems with wall systems on residential buildings in the UK. And during that time, several guidance notes emerged from MHCLG, which started with ACM, then moved to non-ACM, moved to balconies, and then moved to all buildings at any height, essentially. But the reason why a process such as EWS came about and sort of came into our minds to be developed, if we think about almost the basics of the valuation standards and what the valuer and the lender works to, they have long since been predicated by an ability to assume if a building has building regulations or building warrants in Scotland, that then gives you the assurance that the building is built correctly, essentially. In the aftermath of Grenfell and the increasing amount of buildings which have had building control sign-off, building regulations, but found to be requiring attention, it quickly became apparent that in the valuation journey, in the lending journey, and actually in the condition reporting as well, that the valuer, the surveyor, the lender could no longer rely on the building regulations as confirmation that, in the case of the wall system, that the wall system either didn't contain combustible materials or was built in a way which wasn't detrimental to its operational success. And actually, it's probably important to point out that it's not necessarily always just combustible materials, but actually the way the wall system has been put on the building as well. So you have two potential pitfalls there with the wall system. And because of the inability to safely use the building regulations as a way of assuming the building is okay, an alternative process essentially had to be developed. And that's where the EWS came about. So it's a process to allow the building owner to have the building inspected by a competent fire engineer to notify whether works are required. And from that, lenders will know whether there's works coming down the tracks, and therefore does the asset stand up financially. And valuers can also provide a valuation on the property once it's known whether works are required. In terms of in-scope buildings, which is another big question, when EWS was developed, it was an 18 meters plus scenario, which mirrored the guidance at the time from MHCLG. Almost immediately before launch, we had the Barking Riverside fire, which then we had the advice note about balconies. So it then rightly took into account the balcony scenario, which, as you know from the guidance, is at any height. And then since launch, there's also further MHCLG guidance, which is around the sub 18 meter buildings. So essentially a building with a wall system, regardless of whether it has building control sign off, does require an inspection of the wall system to know whether there are any issues with either combustibility and the way the wall system has been fitted. So that's essentially why the EWS process came about, and really it's important to focus on the predication of the valuation process on the building regulations and the inability to continue to use that as a way of assuring that the buildings and the wall system have been built correctly. And that's the reason why the EWS system and process has come about.
Thank you very much, John. That's a hugely informative introduction to this topic. And we covered off the buildings and supplies here. I think one of the questions we received in advance of this webinar was who should sign the form, and specifically it can be people holding ASOC RICS. Are they deemed qualified to sign it under option A? And I know, Andrew, you've got some views on who can and can't sign. So if we start with John and then hand over to Andrew. So who is qualified to sign the form?
I think it's really important to recognise one's own competence and whether we are competent to be assessing a wall system. As a chartered surveyor, then I'm not allowed to take assignments that I'm not competent to deliver, and this is exactly the same. So if, as a chartered surveyor, ASOC RICS, or any of the other professional bodies that's on the RICS list of bodies in the UK, the question is whether you are competent to assess the fire safety of a building. So it's really important for anybody considering whether they are going to get involved with the EWS process from a fire engineering side, that they absolutely do have the competence to be able to deliver this. Within the EWS form itself, there's a description of competence for option A and for option B. So absolutely make sure you're very familiar with what that says. And the other part of this is the professional indemnity insurance, and to absolutely ensure that you have cover and your PI provider knows that you are covering fire safety. So really, competence, it's all about competence. If you're competent to deliver this, then yes, but you must have competence and experience in fire safety and the component parts of being able to assess a wall system.
Thanks, John. And Andrew?
Yeah, it's John's hit the nail on the head there. It is about competence. We have had now a couple of complaints through about MIRPM ASOC RICS members, where those MIRPMs have graduated through to ASOC RICS. And unfortunately, just because they're ASOC RICS, it doesn't mean that they are necessarily competent. If they are also, highly experienced building surveyors and they've got a history of fire engineering, then fine. But the reality is that's very unlikely, and unfortunately, it means that we are having to follow that up. So I come back to John's point, unless you're a fire engineer and you really know what you're doing, MIRPMs, even if you're ASSOC RICS, you shouldn't be signing these forms.
Thank you. And before we go on to some of the key challenges and our sort of meatier topics, I've got a general question for everyone here, which is based on John's description, which I think was both accurate and apt. Are we looking in this at the effect rather than the cause? So is the real problem poor construction and oversight rather than being the EWS1 form that's causing sort of consternation across the sector? Nigel?
Yeah, I mean, I want to step in to defend John on this. There's been a lot of flack being directed at RICS and at him personally for creating this problem. It's actually completely the opposite. If you think about it, you can completely understand that leaseholders are very upset because suddenly they can't sell unless they have the EWS form. Mortgage lenders are quite rightly trying to reassure themselves that they're going to be protected should something go wrong. And the EWS form was designed to try and help on that. It didn't create it. If the EWS form wasn't here, it would be actually slightly worse off. It wasn't as successful as we all hoped, and I was involved on John's group as well. I think we all were. But it's certainly the effect and not the cause. The cause is the lenders, as John succinctly put it, no longer have confidence that what they relied on in the past, i.e. the building sign-off, meant that the building was safe. And once that's gone, they need something else because otherwise they won't lend, and that stalls the entire market. So there's a whole bunch of things that have come together. So the EWS made sense, but then the PI insurance for the people signing it clammed up, so we couldn't get enough people to sign them off. And the other thing to remember, of course, is if the EWS1 comes back and says there is something wrong with your building, you've pretty much blighted that building. But that's not the EWS1 form fault. It's again the fact that the building has been built incorrectly, and it boils down to we don't know what's actually been built.
John.
Yeah, thanks, Nigel. I think I suppose I've been quite honest. I've pinched this phrase from a fire engineer, but it's the compliance gap. I think it's a great way of describing what has happened post Grenfell. And it's what EWS set out to achieve, to deliver, was to bridge that compliance gap. And what do I mean by that? Well, I mean that by banning something going forward, that then creates a compliance gap between new and old. So if you think of an analogy of a car tire, we ban a certain brand of car tire, then every car with that particular brand of car tire will have to have that car tire replaced. In the housing stock, we have a situation where we have new building regulations which bans combustible materials going forward. We have government advice which has a clear decision tree saying that the wall systems must be checked, and essentially it's at any height now. And if there are combustible materials or poor fitting or both, then there has to be a plan to remediation. So in that compliance gap, whilst you've addressed the new build going forward with a new building regulations regime and a ban on combustible materials, what do you do with the legacy housing stock? And that's where we're at. So to answer your question, is there a problem with the legacy housing stock? Well, given the volume of buildings which are found to be requiring remediation, then the answer is there is a need for an inspection regime for lenders, for valuers. And I think also we need to not forget also that the solution here is not replacing one leaseholder with another leaseholder. The solution here is to get to the heart of the problem, which is wall systems on the housing stock in the UK, which require remediation. I think sometimes the sort of hanging your hat on the EWS as being the cause loses sight of what actually the challenge is before us, and the challenge before us is that it's making sure that buildings are safe and the assets are worth what the assets are worth, and you are getting to the sort of the root problem, which is making sure that wall systems are remediated and we have a safe housing stock.
Thank you very much, and I'm going to sort of move on to the key challenges now. So what are the key challenges for property managers in respect of EWS1 forms, and what should they do when a leaseholder requests one? I'd like to hand over to Nigel first and then on to Andrew for their insights on the key challenges.
I think the key challenge can be boiled down to actually getting an EWS1 form, because there's a whole bunch of things that are behind that. leaseholders will naturally expect you to already have one at no cost to themselves, because the managing agent is if you like, seen as the guardian of the building and is the first port of call. They'll also expect you to have it now, not in a few months' time, because it tends to come up from what I've heard, not from people sitting in a block saying, actually, I wonder if this block is safe. It comes from people saying, I want to sell, or I want to remortgage, and my mortgage company wants this and they want it now. So it's not something that you can kind of come back to a little bit later. I think a big challenge, which John and Andrew touched on, is do not sign it yourself. I know some managing agents have done that because they want to help, but you are just opening up a whole world of pain, because as John said, you're then giving the problem to another leaseholder. You're actually taking on a horrible liability problem yourself, because you have just signed off that building is safe, and the new leaseholder quite rightly can say, I bought based on that, and now I'm facing a £50,000 bill. That's not mine, that's yours. So that's an awful thing to go for. I wish I had great news on this call. We've figured out how to get around this. I don't. There's only one solution I can see, which I'll come onto a minute, but that's not likely to happen. Other issues you're going to face, challenges. We are seeing that lenders are asking for these out of scope. So the 3-story brick built building. And I think one of the problems is the administrators in lenders are following a checklist, and they see the word flat and they go, oh, that means I need to get an EWS1 form. Some people have managed to argue back, look, it's not 18 meters, it's not got cladding, it's not got combustible material, so you don't, and they've managed to push that back. They tend to be the larger firms where they've got a bit of weight behind them. But a lot of the time you're trying to push water uphill. So that, again, is another challenge that it's been seen as required for everything. Other challenges, so I've got my list here. As I said, we simply do not know what has been built. So is it a brick slit with EPS behind it, in which case that's combustible, or is it solid brick and it's fine, there's rock wool behind it? We don't know, and the only way you can find out is to open up holes, and not a hole. Again, a problem. You've got a building which is 10 stories. The contractor might have used one supplier for the first 4 stories, and then a second supplier for cladding in the next 4 stories, and then somebody else to fit the top bit, and so forth. So again, you have to start pelting holes all over the place. Cass is going to come on to the particular issue of that one. Other issues, sorry, I know this is sounding very depressing, but it is a depressing subject. Finding suitably qualified contractors prepared to sign it. So we have the PI issue there. So we're all painfully aware of actually trying to find a surveyor who has sufficient PI to do that, and also, as Andrew will attest, is prepared to take on the long-term liability that, having signed that off, will haunt them for the next few years. And I guess the final thing is, if the EWS1 does, as I mentioned, show there's a problem, you've just opened up a whole world of pain for a whole load of leaseholders in terms of their own psychological well-being, their financial well-being, their ability to move jobs, etc., etc. So challenges are, this is a very, very horrible time for leaseholders. I mentioned the solution. Frankly, the only one I can see is an enormous one, which is where the government totally steps in and says, doesn't matter, we will take care of the whole lot. So therefore, the valuation shouldn't be influenced because it won't affect anybody. We won't be going to the lenders, we won't be going to the leaseholders. But that would be so, how many tens and tens, if not hundreds of billions of pounds? I can't see the government doing that. But otherwise, I can't see a way out of it, because the lenders, quite understandably, want to know that they are lending and they'll get their money back and it's secure, and that won't fall into negative equity because of the cost of remediation. So not much of a happy one there, but that's the reality as far as I can see it.
Thank you very much. And Andrew, what would you like to add to that in terms of the challenges that your members are seeing, or challenges that they may be facing?
There's not a lot to add. That was a pretty comprehensive answer from Nigel. Thank you very much for that. There are a couple of things. I think I would reiterate supply and demand. Now that buildings under 18 metres are in scope, the number of buildings to be inspected has increased manyfold, tenfold plus. Meanwhile, because of PR restrictions on the fire risk engineers, the number of engineers that can actually sign the things has declined dramatically. So what we've got is a very, very adverse supply and demand situation, and it can take months or years even to get an inspection carried out. But a couple of other points. I think There's John alluded to it earlier. There's the issue of what is the right thing to do. He was talking about somebody signing off, the internal failings on a form. But I mean, a year ago plus now, we've been asking members, if you have reason to suspect that the building is not safe, what should you do? And it was a sort of a moral, ethical question. What are you legally required to do in terms of an inspection, and what should you do? And we put our members through the ringer on that at the regional seminars. And there is not necessarily a right answer, but it's something to think about, because if you have reason to believe that the building is not safe, then you're following a different course of action already, and you may be sweeping up the EWS1 simply as part of those inspections. But I think then the other point, certainly from a member point of view, is that property managers are the messengers. The leaseholders are innocent here. They didn't build these buildings or sign them off, and they're being landed with big bills, and it's not fair. And you can understand why they're angry, and you can understand why they're fearful. You can understand why they're upset, and rightly. The problem is that the building manager did not build it or sign it off, and also is not culpable for the situation that they're in. But of course, the building manager is the person that is carrying that message to the to the leaseholders. So it's a rough time to be a property manager at the moment. You are the messenger, and getting shot on a fairly regular basis. So it's important, I feel, for property managers to, when being shot at, it's just trying to understand, and I remember, property managers too, why it is that leaseholders are so upset. It is a very unjust situation.
Thank you very much. And we've got a huge number of questions coming in that are being moderated and sort of compiled by my colleague Remy, and we'll come to those, and we'll make sure that we have sufficient time at the end to deal with as many of those as we can. I'd like to move on now to what I'm describing as one of the thorniest issues. I think we've identified some thorny issues already, which is who should pay for the cost of an EWS1 form. And Cass, I know that you were very keen to pick up on this, so if I could hand over to you, please.
Yes, I think you're absolutely right that aside from the question as to do I need an EWS1 form, the second biggest question to tackle is, well, if I do need one, then who's going to pick up the tab for this? Who's going to pay for it? And as a lawyer, I am expected to advise and expected to give answers, because it's my job, it's what I'm paid to do. And when I advise, when I give answers, I rely on authority for that. I go to the statute books and see what legislation tells me, and I go to the decisions of the courts and tribunals and see what they tell me as well, and how they help me interpret statute and perhaps tell me about the approach that I should take. So I go to those two sources. And this is where I run into a bit of difficulty so far as the EWS1 forms are concerned, because I run into difficulty in finding where perhaps the courts and tribunals have been dealing with the cost recovery issue. So what I've done instead is had a bit of a look round as to what's happening in practice with EWS1 and how are those costs being recovered and who are they being recovered from. I started that by looking at really how many have been done. There's an article and some stats on the Fire Protection Association website. I think it's actually stats that are taken from RICS, and John will be able to confirm that talks about in the region of 860, give or take, of these forms having been completed. So if we have over 800 having been completed, then somebody has paid for those. Who is it that has paid for them? Well, for that, I turned to a committee report from the Housing Communities Local Government Committee that came out back in June of 2020. And that report sets out three broad concerns so far as EWS1 is concerned. And one of those concerns that sets out in that report is headed high costs passed to residents. And the report says, and the report acknowledges, that the costs of these surveys, so the EWS1 surveys, are often passed to residents, and it talks about the level of costs being high and gives various examples in that report. So it seems to be that residents are paying for these. Now, there's a House of Commons briefing paper from a few days after that report was published, and again it references what the report says in relation to the costs being passed on to residents. So what seems to be happening in practice is that these forms are being commissioned, that they're being commissioned at cost, and that the costs associated with the commissioning of those reports are being passed on to residents, and I must assume, therefore, that the costs are being recouped by the service charge. And where we're dealing with service charges, it's all very lease specific, isn't it? And the ability to recover costs depends on whether there is a particular clause or clauses in the lease that would allow that certain head of expenditure to be recovered as a service charge item. And anyone involved in residential leasehold and services and service charges knows that there are two really broad elements when we're dealing with service charge and service charge recovery, on the assumption that these are service charge costs. First one is, does the lease allow for this specific item of expenditure to be recovered via the service charge mechanism? And then secondly, if you are able to negotiate that hurdle and find a clause in the lease that you can nail your colours to and say, this is the clause that allows me to recover the EWS1 costs. The second question is it reasonable to incur costs in that particular way? So we have two elements when we're looking at service charges, liability and reasonableness. And as lawyers, I spend my life looking at those two particular questions. Now, when we're looking at leases, there isn't going to be a specific clause in the lease that references EWS1. What we're going to be looking at instead is to see whether there is a more general clause, so a sweeper clause, as we would call them, that allows the courts and tribunals to decide that these kind of costs are recoverable as a service charge item in accordance with the terms of the lease. And that's going to come back as well once you've negotiated that hurdle to the perennially thorny question as whether these costs are reasonably incurred. Now, I've done a scout around in relation to tribunal decisions and court decisions. To my knowledge, there are no upper tribunal decisions on this and on the issue as whether EWS1 costs are recoverable under the service charge and whether it's reasonable to put these kind of costs through the service charge. That's perhaps not surprising because the form hasn't been around a huge amount of time and the cases perhaps haven't worked their way through the tribunal system and up to the upper tribunal. So I'm not entirely surprised that there are no upper tribunal decisions as yet in relation to EWS1 costs. I have, and with the assistance of my team as well, trawled through to see whether there are any decisions of the first tier tribunal on EWS1 costs. And I can't find any of those either that specifically reference leaseholders challenging costs in relation to EWS1, or indeed landlords going to the tribunal to say, please, can you give me a predetermination that it would be reasonable for me to incur the costs associated with this EWS1. If there is anybody watching this webinar today that knows of any tribunal cases that deal with the EWS1 point and the recovery of costs via the service charge, then let me know. I'd be interested to see how the tribunals are dealing with those kind of issues, because it seems to me that costs are going through the service charges, but I can't see how the courts and tribunals are dealing with it, if indeed they have been called upon to deal with it as yet. We do have that handful of cases there in relation to Waking Watch, and we know about the cases that have gone through tribunals in relation to remedial works. But like I say, I'm struggling to find anything specifically on EWS1. So we're in a situation where it seems we're passing the cost of EWS1 back through the service charges, back through to the leaseholders, but there's no judicial scrutiny as yet on that kind of cost recovery and whether the service charge actually permits those costs to be recovered. So the things that I would be advising managing agents to do at the moment, because I'm asked this quite a bit, is to check your lease. Is there a clause in the lease, if you're intending to pass this back through the service charges, that permits recovery of the costs associated with this kind of report, with this kind of investigation? And remember that these are lease specific. So just because one lease that you have for one of your developments may have a clause that on the face of it allows recovery, that's not necessarily going to be the case for the development that you manage down the road. So check your leases. And then look at whether it's reasonable, and it's this issue of reasonableness, to incur costs in the commission of that EWS1 form. If you are a landlord or a management company and you're worried about cost recovery, you think that there are going to be challenges, then you have the option to go to the tribunal for a predetermination under section 27A3. You can go to the tribunal and say, we intend to incur the costs associated with this EWS1 form. We think that it's recoverable under clause 4.3. We think that it's reasonable under section 19.2 for us to incur these costs. Please, judge of the tribunal, can you tell me that those costs are recoverable and that it's reasonable for me to incur costs in the way that I'm suggesting? So you can go and get that predetermination. But it's also worth mentioning that EWS1 and the cost of EWS1 is just part of the picture here. It's when you start carrying out these kind of surveys and investigations that you realise the state that the buildings are in, and you realise that there are perhaps further works that will be required and interim measures might be necessary, remedial works will be required. This is just the tip of the iceberg, I would say. Perhaps that's a conversation for another day.
Thank you, Cass. Andrew, you had something to raise on that.
So the EWS1 is effectively part of the lending process, isn't it? So it really came from the lending community for lenders to decide whether they were going to advance finance or not on a unit. But what it is doing is it's certifying the outcome of an inspection, and that inspection is deciding whether the building is safely clad, whether it has a safe wall system or not. If we park the EWS1 and address the question, if we believe that the external wall system is suspect, should we be inspecting it? Forget the EWS1, we should be inspecting it. If that is the case, and the lease permits recovery of safety inspections under a general sweeper clause, because of course you are, as a manager, trying to establish that the wall system is safe in compliance with the government's consolidated advice note, then the cost of the survey at least perhaps could be recoverable through the service charge, and while you're at it, go and get an EWS1 form signed off at the end of it. Discuss. What's Cass's legal opinion on that?
It seems a pragmatic solution to me, Mr. Bulmer. I tend to agree that there is likely. Sorry, Andrew, go on, I interrupted.
We're not giving legal advice today, but go on. Sorry, I interrupted you.
I was going to say that there is likely to be a clause in the lease. The clauses will be written slightly differently from lease to lease to lease that allows you to be able to recover the costs associated with doing your suitable and sufficient assessment by the service charge. And I tend to agree that there is scope for the EWS1 being done as a bolt-on to that rather than being the point of concentration for that assessment. That's perhaps what you're suggesting.
I'm sure that's what I said. Yes, thank you. Yeah.
Andrew, sorry, Nigel.
Yeah, no, Andrew and I do look very similar. I mean, one observation was presumably that a lot of this won't have washed through the service charge accounts yet, because they take up to 18 months from expenditure, and EWS has been only with us for about 6 months. So there might be a lot of this comes to light, because if you think about it, you only know about the EWS because you're selling. The other leaseholders are sitting there, quite happy, not aware of all the trouble that's going on around them. So we might see this coming up a bit more. With that in mind, and the likelihood it could go to tribunal, again, plea to members, make sure you explain and have documented why you felt it appropriate to go down that route, what part of the lease you relied on. So if you haven't gone for dispensation, why you thought it was unsafe, how you chose the contractor and the costs, etc., because it could well get very ugly depending on the costs. And, if you go for a BS 8414 test, that's £45,000, and it takes about 6 months to get, because you're burning something about 9 meters tall. So there can be significant costs involved as well. But speaking as ARMA, make sure you look after, you just protect yourselves as well, and document what you've done and why, because this is, it's unlikely that this will just carry on being put on the service charge and everybody will remain quiet, because as a leaseholder myself, I'd be pretty unhappy about it. As Andrew said, it's not my fault.
Cass, what's the situation on tribunals at the moment? I know it'll vary, but what's the situation on tribunals in terms of the time? If you decide that you think, well, let's cover our back on this, and Nigel's point is well made and correct, If you're going to cover your back on it and you're going to go to tribunal and get dispensation, what's the situation at the moment? I know we've got COVID, we've got delays. Any sense from a legal perspective on the practicalities and costs of doing such a thing?
Yeah, I think you both raise a really good point in relation to terminology that you're using, and you've both mentioned dispensation. Dispensation is going to kick in if we are triggering Section 20, and Section 20 is going to kick in if we are carrying out qualifying works, so works to a building or other premises. There's a question that I get asked a lot about whether doing an EWS1 or doing this kind of survey, this kind of investigation, does trigger Section 20, whether these are works to a building or other part of. So I'm not sure that dispensation or consultation is actually what's necessary here. What I'm proposing is that if you are incurring costs and you are worried about being challenged in relation to those costs, that you go to the tribunal and you ask the tribunal to exercise the jurisdiction that they have under Section 27A and its subsection 3 that enables the tribunal to say, before incurring a cost, is that cost payable as a service charge? If so, who to, by whom, etc., 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 so that you have in your back pocket, before you spend that £40,000 of somebody else's money, that determination that tells you that you can spend it, that those costs are recoverable under the lease, and also that it's reasonable for you to have spent somebody else's money in getting this kind of survey. But going back to the point, sorry, Andrew, jump off my soapbox at that point, going back to the point that you were asking about tribunals. At the beginning of lockdown, I think it's fair to say that the tribunals were finding their feet in relation to their workload. My experience, certainly in recent weeks and months, is that tribunals are now on their feet, or certainly much more stable than they were with regards to their workload. So things are moving forwards. Urgent cases are being dealt with. The non-urgent stuff is progressing and being dealt with as well. It's being dealt with in a different way because I don't believe that any of the tribunal officers are open yet. So it's a lot more paper determinations and a lot more remote hearings using the tribunal's video cloud platform facility and also using Skype. But stuff's moving in the tribunal, so don't be afraid and don't think that it's going to take 18 months to get an application through. It won't. They're moving quicker than that.
Thank you.
Does that answer your question?
Thank you all very much. So I'm conscious that we've got about 3 pages worth of questions that have come in from the audience, and I'm keen to ensure that we pick up on some of the major themes that have been asked. Before we turn to that, I think we may actually have to skip the brief panel discussion we have planned to allow sufficient time for the audience questions. Some of the questions we have previously been asked are around future changes. So is the position of lenders changing in light of the challenges in getting the forms completed? And what does a zero valuation mean? I'd like to hand over to John and then Nigel on that, if that's okay.
Yeah, no problem. I think the zero valuation gets confused with what the actual process is. Those of you who have ever been involved in resi secured lending will be familiar with the zero valuation. It's a mechanism to prevent lending until further information is obtained. It's a common way of stopping auto underwriting from proceeding until you have a further report. And zero valuation is used in structural movements and dry rot. So when you hear the headline, which is quite headline grabbing, which is my house, so my flat is worth nothing, it has a zero valuation. It's not the valuer and the lender saying it has a zero, it doesn't have a value. It's saying that we can't lend at the moment until we have further information. So it's really important to remember that. It's not stating that an asset suddenly has a value of zero.
Thank you. And Nigel, is there anything you'd like to pick up about the position of lenders or zero valuations more generally?
No, I don't see the position of lenders changing particularly much at the moment, because what this is all boiling down to is getting somebody else to accept liability if something goes wrong. And the lenders are not going to turn around and say, actually, fair enough, I'll take that. They want the surveyor or the fire assessor, or rather their insurance, to accept the liability should something terrible turn out to be the case. So I don't think that is likely to change. I'm afraid that, again, it seems to be my job at the moment to give bad news to everybody on the call. But I think that's just the reality. So sorry, I can't sugarcoat it.
Yeah, I think it's we're having the conversation because there are issues with buildings, and until that is addressed, then the lender's concern, I would suggest, will remain as they are now. Ultimately, as I said before, we need to remember why we're having the conversation, which is there are water systems which are routinely found to be defective, which does affect a buyer's decision to buy. It does affect a lender's decision to lend, and it's important that everybody in the food chain, as it were, is fully armed with the facts before they proceed. So yeah, I think that given where we are, the situation will change for as long as there's uncertainty around the buildings.
And there's more to it than just the external wall systems, because quite understandably the government won't lend on the external wall system if there's compartmentalization, fire doors, etc., problems within. And that is, I mean, Lord Greenhalgh was very clear on that. That is not part of this fund. So if you find a building, you examine it, you find the cladding needs replacing, you apply to the fund, and the fund says yes. You then have potentially the problem of going to the leaseholders and saying, well, before we can get access to that money, we need to raise from you X tens or X hundreds of thousands of pounds to put right all the other stuff, which also is not your fault. And by the way, we've drained your reserves with the Waking Watch. So it really is, again, I'm getting more upset as this call goes on. It's an awful situation, and it's something we are all working really, really hard with government to try and figure out a way. But apart from an unlimited magic money tree, then it's very difficult to see a way out at the moment.
Thank you. And so, absent a magic money tree, what is likely to change in the coming months in respect of EWS1 forms? And I've just scanned through the questions that have come through. Quite a lot have come through about PI problems and the availability of funding. So Nigel, would you be happy to talk to both PI and availability of funding and how you see that developing?
Yeah, there's two issues on PI. One, the more personal one with ARMA, which is our members are being hit with quite considerable hikes in their own PI because, rightly or wrongly, they are being seen as part of the construction industry. And we have been having chats with the CEO of Beaver to try and see if we can carve property management out, because the argument is that we're surrounded by contractors, each with their own PI, so maybe we're not quite such a bad risk. So those discussions continue. The PI that specifically affects this is trying to get the fire assessors and the surveyors who are willing to do this. Their PI actually covers them to do it, because if you're only covered for 250,000 and it's £4 million worth of works, you can't really opine on that. And again, discussions going on through Beaver and with government to see if there's a way that government, and again, I know I keep saying government, but this is sort of the scale of the problem that only governments can help with, to see if there's things that they can do to help. So, for example, underwriting or indemnifying the fire risk assessors, because the problem is if the fire risk assessor signs something and is wrong, then they're going to get nailed to a cross if they're wrong. Whereas if you kind of say, no matter what, you can sign that form and you won't be carrying that around for the next 12 years on your insurance, that might help, and that's something government can do. It's not saying we'll take all the PI, it's just saying, tell you what, we'll take the first tranche of risk, or we'll provide a system to do that. So again, there's lots and lots of moving parts, and everybody's desperately trying to figure out a way through this. I don't think anybody's really burying their head in the sand. It's just incredibly difficult to find a way through that works quickly as well.
Thank you. And Cass, would you like to sort of bring in the fire safety bill and how that might interrelate with everything we've talked about so far today?
Yeah, we have a couple of draft bills working their way through Parliament at the moment. We have the fire safety bill and we have the building safety bill. The idea of the fire safety bill is that it clarifies really what the current position in law is, but it's the building safety bill that is going to introduce a whole new landscape really for regulation of buildings, management of buildings, and also who pays for the costs associated with this, because it's all well and good that we introduce this new regime for buildings, and that they're built correctly, that they're managed correctly, and that they're safe, but it comes at a cost. And the building safety bill introduces this new concept of building safety charges, and these are sums that are, if the draft bill goes through as it is at the moment, sums payable by leaseholders for building safety costs, and building safety costs are costs incurred by the accountable person in a high-risk building in connection with the carrying out of building safety measures. So there are and there is legislation coming down the track at a cost.
Thank you, Cass. Always at a cost. And Andrew, this is, I think Nigel's described it as, this is complicating a government level sort of situation to be unpicked, but how do you view the EWS1 requirements and the sort of other requirements that sit around it?
Let's go back to John's point. The EWS1 is simply it's an indicator of a wider problem. If you pick up Cass's building safety bill point, the point is that ultimately somebody is going to have to certify a building to the regulator. There'll have to be a building safety case. And if the building safety bill comes in next year-ish and the regulations that sit around it come in the year after-ish, and then there's a couple of years to comply, within 4 years, 3 to 4 years, you're going to be in a situation where big buildings will be certified by the regulator. And at that point, who's certifying whole building safety? So there is going to be a need to start looking at these buildings anyway, irrespective of the EWS1. And I think the EWS1 will start to get swept up in the greater momentum of the building safety bill. And the positive, if there is one, is that some years from now, and it will take years, we have only so many fire risk engineers and so forth, we are going to have safer buildings that are being certified. It will come at a cost, and the leaseholders will be picking up the ongoing costs for that. But if that's what it takes for safe buildings, then so be it. So there is hope, I think, on the horizon. In the meantime, what I can confirm, and Nigel is copied into the same correspondence, is that we've had a somewhat lively exchange of opinions with government, been building up, and most recently during the last few days, where we've been very clear about the harm that is being caused to leaseholders. Property managers are in the firing line as the messengers. And the response that has come back has been very clear that government does understand the harms and the pressures, the PI issues that are being visited upon professionals, the building insurance premium hikes that are being paid for, and so forth. So government are now well aware of this, and the insurance industry is well aware of this. And at some point, somebody has got to have a brave conversation where they move to a solution, because what is quite clear is that the property managers are not able to solve this situation themselves. We didn't make the situation, and we're not going to be in a position to solve it. We can facilitate it, we can message it, we can talk to people, but ultimately government and the insurance industry have to get their heads together and solve this.
I still need to say thank you very much, Andrew. In light of the volume and variety of questions that are coming through, I'm going to suggest we skip the panel discussion and move on to some of the audience questions. We've had so far 8 questions which are around the same theme, and perhaps it's a recap as much as a sort of further explanation. Which buildings are caught by the EWS1 regime? And what ought property managers do if they're being asked to produce or procure the forms for buildings where it would be inappropriate for them to be required? And given that this is an audience question session, if you would like to field any of the questions, please just raise your hand and I will hand over to you. John.
Okay, I'll start with the thorny question of in-scope buildings. When the EWS was developed, the rule set at that time was 18 meters plus. That was the accepted point where there is the greatest risk. I would suggest, and I'm sure everybody will be familiar with the MHCLG advice, consolidated advice notes of January this year, and the rule set that contains. Whilst the EWS process is headed 18 meters plus, or where specific concerns exist, and that was done for the Bolton Cube, which was 17.6 meters, I think. Given the consolidated advice notes and the known issues with buildings below 18 meters, you will see routinely lenders and valuers requesting an EWS where they consider there to be a risk. Our own Q&A on the RICS.org is steering towards 4 stories plus. That's the accepted point generally, where the greatest risk to life is presented from defective wall systems. I say defective into the loosest sense of the word. That said, we are also seeing more often than previously evidence of 3-story buildings with considerable amounts of wall systems on the outside, which are potentially combustible. Does that affect value? Does that affect safe occupation? The answer in some cases is yes. So unfortunately, the advent of the MHCAG Consolidated Advice Notes in January has essentially brought under 18-metre buildings into some form of inspection regime, and the only inspection regime out there is the EWS. It's a bit of a long-winded answer. It's quite difficult to answer, but essentially you are looking at sub and post 18-metre buildings.
Thank you. Nigel, I saw your hand raised.
Yeah, just as an aside from that, one of the many discussions that's going on with MHCLG is to expand the concept of risk to come up with a risk matrix approach, rather than just, is it 18 meters and does it have cladding? Because those are very binary questions. So it might be 18 meters with a tiny spandrel over a single window. Does that risk the whole building? So early days on that, but for example, Ballymore, they put forward a proposal for risk matrix into government about a month ago, and so discussions continue, because that would be a more sensible way to look at it.
Yeah, sorry to cut in, agreed. We are working on a risk matrix with a number of other parties. It's challenging, but yes, we are working on it.
I'd like to move on to the second set of questions, and apologies if we don't answer your question directly. We're trying to sort of bring them into themes, which is to what extent should we be proactive about this? So even if we haven't yet, as a managing agent, been asked to provide an EWS1 form, should we be looking to proactively go across our portfolio for those buildings where we think one may be required upon sale? Nigel, your hand is up.
Yeah, I mean, we're talking safety here. Let's be horrible and put the question the other way around. There was a fire in the building, somebody died, and I hadn't bothered to check because I thought it might be all right, or I wasn't sure. So I'm sorry, it's a horrible thing to do, and it's horrible for the leaseholders, but we need to know that these buildings are safe, because what we already know is the likelihood is what's been built hasn't been built terribly well. So I'd err on the side of caution there. John,
Yeah,
would you like to disagree with me?
No, I agree entirely. I think there's clear advice from MHCLG about that. I routinely have thrown back at me, it's not a regulatory requirement, so freeholder isn't going to oblige. And I would also say that sometimes the EWS is seen as an administrative process to a mortgage offer. It should be seen for what it's set out to trying to achieve, which is the safety of the building. So I agree entirely with what you're saying, Nigel.
Thank you. And I'm going to go to the other side of the complete other end of the spectrum. So rather than proactively doing it, what happens if one has been requested, but there is an inability to procure a competent person to be able to do it, or particularly where the typical people that a managing agent might deal with do not believe that they have the PI or cannot get the PI covered. I know PI is something that we've talked about, and perhaps a sort of pool or insurer of last resort, even on a tranche basis from the government. But what should managing agents be doing, and how should they be corresponding, communicating that back to leaseholders who've requested one? Would anyone like to pick up on that?
I think my response would simply be that there is no good answer out of it. It's if you're at the end of a queue, you're at the end of a queue, or get in line, as they would say in America. But it's about being transparent with the leaseholders and with the freeholders. That's the situation.
Thank you. And in terms of qualifications, we covered off at the beginning. In fact, John specifically covered off at the beginning about the concepts of competency and the ability to sign. There are a few questions raised about that, but the specific one that I'd like to turn to is, what qualifications do fire engineers require to be competent? So what is the objective measure of competency? We've described competency in a loose sense, but is there anything specific, or is it the ability to be competent?
Yeah, good question. It really is a good question. Each professional body will have its own designation, essentially, and each designation means different things, which is proving quite challenging. So an associate of one organisation doesn't mean the same thing as an associate of another organisation. The IFE have put out guidance which says for option B they should be chartered engineer. They should have the chartered engineer qualification alongside the IFE qualification. My advice is to have the conversation with the engineer and to see what experience they have and what is their competence in assessing wall systems. There is no one size fits all, unfortunately. There's no single qualification out there in the UK that everybody has signed up to, and you could go through chartered, the CIAT or RICS or IFE or FIA. All their designations mean different things. But I suppose just to say though, we are aware of it and we are looking at what we can do to provide some more clarity. But I think the advice at this stage is to speak with the engineer and see what experience and level of competence they have for assessing wall systems.
Thank you. A few questions have come in around the same subject. So, to what extent has the information and the discussion we've had today, to what extent is that applicable in Scotland, or are there any variations that people ought to be aware of? Would anyone like to put up their hand to address that?
I can say that. Yes, there are the major difference in Scotland is the way home ownership operates. And you don't have the single entity responsible for fire safety, so you don't have the RRO. So the property factor essentially needs to get agreement from the individual flat owners to move forward, and that's the challenge that is happening north of the border. From an RICS perspective, we are having conversations with the Scottish government quite regularly to see whether there's any movements in how legislation is going to operate there. But that is the major challenge north of the border, is the way the home ownership operates, and actually just the procuring of an inspection of the wall system is the most challenging bit, I would say.
Thank you very much. I'm going to be cheeky and try and squeeze in one more question, and I really do appreciate all the questions coming through from the audience. To what extent, if any, is there an expiry of an EWS1 form, or to be phrased a different way, with what frequency might a managing agent need to renew or procure a new EWS1 form? Is there an expiry, and is there a cadence?
I'll go again if that's okay. I'm sure you'll be okay. When we developed the EWS, we had quite significant conversations about this. We have put out there that it has a shelf life of 5 years. That was deemed to be an appropriate length of time, or shorter if works have been completed to the building that suggest its original assessment is no longer valid. So if you have, say, an A1 rating and something has happened in the intervening period, which alters in the valuer's mind that the wall system may no longer be safe, then a new EWS will be required. But the process itself does confirm it has a shelf life of 5 years.
Brilliant, thank you, and thank you all very much. So thank you to the audience for tuning in. We hope you find this both informative and interesting. Thank you very much to our panelists for sharing all of their expertise and insights. For ARMA members, IRPM members and RICS members, you can log this, the viewing of this webinar as 1 hour of CPD, and I would encourage you to do so, and we're very grateful to the organisations for recognising this webinar. I'm very grateful to Cass, to John, to Nigel and Andrew for giving up their time and sharing what I'll describe as their honest insights on what is a very thorny set of interrelated issues. If you have any questions for us or any feedback, we'd love to hear from you. Please email research@fixflo.com. And the final thing to flag is the next in our series of masterclasses is looking at how block managers can grow within a management business. So we're going to be joined by Nick Rich, former COO of Warwick Estates, talking about his journey, some of the pitfalls he had, and how he went from an assistant property manager to leading a team and leading a business. So if you are interested in hearing from someone who has gone down that journey very successfully, please tune in. And just a final thank you to all of our panelists and all of you. I wish you a very good afternoon. Thanks and goodbye.